Sir, with your permission, should we begin with the formal introductions at least, and the rest of the participants can join as we progress?
Sure.
So, welcome everyone and warm greetings from the Legal Voice. The Legal Voice is an innovative legal startup committed to making high quality legal education accessible to all. We specialize in webinars and certificate courses on a broad range of legal topics, often extending beyond the traditional law school curriculum to promote diverse perspectives. Our expert led online event today on artificial intelligence and law offers comprehensive insights into the intersection of artificial intelligence, intellectual property rights, and copyright law, delving into the legal challenges and opportunities that arise with AI driven innovations. You can today gain insights into the evolving legal landscape and strategies for protecting AI based intellectual property and copyright. Professor Shauvik Kumar Guha is today's speaker, and he will be speaking on artificial intelligence, residuary IP, protection, and infringement. Shavik sir is an associate professor at NUJS, and he's also an associate director for the Center for Aviation and Space Laws, along with being the assistant coordinator at the Center for Law and Technology, NUJS. Please join me in welcoming Guha sir. And on to you, Guha sir, for the main event.
Yes. Thank you, everyone, and thank you for the people who are of both the organizers as well as the participants of this program. Um, uh, so I have been told that the previous session has been on AI and copyright, and that's actually befitting since most of the discussion currently involving AI and IP has been overwhelmingly towards copyright, and to a certain extent about patent, of course. And what I have felt in course of my own work and research with AI, most of which is actually been interdisciplinary because I work with the tech people a lot in this regard, is that you know there is no particular uh, development of AI regulation that can take place in our country in silos. So it can't be a separate, isolated development. So each of the uh, breakthroughs that are happening in any field will have repercussions that will reverberate throughout the legal regimes. M's case in point was this discussion, and those who work in the field of AI and law would be aware of the fact that there's this argument that trying to have uh, one dedicated legislation for governing AI would be sort of like having a dedicated legislation and for governing activities related to horses. When this was said by a famous AI scholar, and they said that we don't have a legislation for horses, right? So we do have legislations which involve governance of activities related to horses separately. So if we are keeping the horse as a pet, we have legislations like prevention of cruelty to animals, which will be useful. If we are using it for racing, then we have another set of gambling and betting laws. If you are using it for the purpose of driving a vehicle, then there are other purposes, other provisions, etc. So all of that makes sense. But to have one legislation which will cover everything to do with horses doesn't make sense. So somewhere a lot there is this school of thought in AI, which is becoming more and more popular, who's saying that there is no use having one solitary regulation that will deal everything that is there to do with AI. Rather, we should have look into each of our existing regulations in multiple spheres and try to figure out how to make them capable of dealing with issues which are arising in those spheres because of the increasing use of AI. So IP laws, they traditionally assume that we have inventors, we have designers, we have authors, creators for different kinds of works that get IP protection. They're all human beings. That's the assumption, traditional assumption at least. And today's rapid advancement of AI, especially if we consider developments like the LLMs, large language models, generative AI models, etc. So that is already having a deep impact on the existing business and society. If you look at the projections on AI, future estimates, that sort of provides an indicator for the entire game-changing nature that AI has. So there is this PwC report which talks about the fact that by 2030, AI could contribute up to 15.7 trillion US dollars to the global economy, more than and the current combined output of India and China taken together. So if we, I mean, therefore, the governments are now recognizing the potential impact of AI, right? So they have started formulating plans and policies to harness the benefits of this technology. And at the same time, they're trying to also control the risks with different degrees of achievement. Now, today we have AI to help us write codes, but it can also design new drugs. It can develop new products. It can redesign existing processes, making them more efficient and customized. It can create graphic designs, artworks, and several other creations and innovations. But it is these abilities of AI that have given rise to, series of legal questions, like, if there is an AI model which is generating a piece of visual art, do we have copyright protection for that? If there is an AI system which is devising an invention, can we have patent protection over that? So if an AI model is actually generating any kind of output, so who will be considered as the owner of the output? And similarly, if that output, on the flip side of things, if the output is infringing another person's IP rights, then who will be held liable for that purpose? So all these questions, these queries to exist. And as a response to these queries, multiple jurisdictions across the world today are, studying this interaction between different forms of IPR and AI very closely, because the implications that AI has for IP laws are multifaceted in nature, and industries are now demanding a clear, forward-thinking, adaptable legal frameworks or guidelines in this regard. Now, if you uh, consider discussion about AI and IP issues, you would need to make a distinction, in my opinion, between AI assisted inventions and other works and AI generated inventions and other works. So there is a scale with which at one end AI is being used as a tool, as an instrument to help human beings develop new works, inventions. These are the AI assisted variety. There is a human being in the loop. Whereas, there are examples where AI has been part of the inventive or creative process, but without the involvement of a human being in every single step. When we're talking about AI assisted work, arguably that's no different from, if the human being is using any other tool. If I'm using a computer to write something, well, does this mean that the computer has any ownership over the work that I'm creating? No. So when AI assisted works are being considered, a lot of people believe that this is the same thing as using any other technology, any other instrument. But the question is, of course, where AI has more what we refer to as cognitive abilities, where the AI is capable of generating the invention or work with no human intervention or very, very limited human intervention, AI generated work. And it's important to also understand the complexity of AI, because, when we talk about an algorithm today, it involves multiple players. There is the owner, there is the programmer, there is the user, and all of these people play a part in the overall creation of eventual AI generated output. So, mostly, as I mentioned, issues on patent and matters of copyright, these dominate the conversations about AI and IP. But there are other kinds of AI also. Because of this recent boom in generative AI, there's been a lot of attention on issues of infringement in when these AI systems are being trained. Who should be held liable if there are infringing third-party IP rights? But a lot of it is now still subject to speculation. So discussions regarding other IP rights like designs, trademarks, digital replicas of individual persons. So, these are not that popular yet, but these are happening. Okay. And, we will have to keep in mind that whether, and if so, how IP laws should be adapted to accommodate AI in its output. In fact, in several areas, the role of AI is already testing the limit of IP laws. For example, whether AI can be an author, an inventor, and so on and so forth.
But the answers do not come from binary approach of extremes. I would say it comes from a more nuanced appreciation of where the balance ought to be struck. There's this one complicating factor, as I mentioned, is the existence of multiple stakeholders in the AI IP ecosystem. And we need to navigate the various tensions among these players, including who should be liable for AI generated output that might be in infringement of third party IP rights. And at the same time, you also have to remember that while there are common issues that concern every kind of IP, still we can't have a one size fit all solution for all kinds of IP. Right? Because we have the legislation, the regulatory frameworks surrounding different IPs are different. Think about it. Originality in copyright law and novelty in patent law. They are different concepts. They involve different standards, although they may seem on the face of it the same thing. And if we start with patents, patent protection is supposed to be on bedrock of innovation. Inventor is given a time-limited monopoly to exclude others from using the invention. In return of that, they're disclosing the secret behind the invention to the public. And the public can then tap the knowledge, further innovate, improve upon that. So if we, of course, different patent systems all around the world, they do differ on certain points, but there is a common thread that runs through their design. Patent protection is intended to incentivize human ingenuity. And when AI is on the rise, then that raises the questions that, does the patent law have any role to play in protecting the innovative output of AI? And when I say innovative output of AI, I mean AI generated inventions, not AI assisted ones. Now, because when we have humans involved, there is arguably less controversy of the possibility of protection under existing patent law. Right? But we also have to remember that the AI involvement is not a binary thing. It exists on a spectrum. The discussion shifts from AI that automates to AI that invents autonomously. And as we keep on shifting in that direction, the legal implications become far less clear. So there is this, there's this threshold question, very initial question, whether AI is even capable of autonomous invention or not. What we are seeing all around us is that yes, it is. So there's this AI system, Dabus, DABUS. So it has supposed to have invented something like a food container and another flashing beacon. Okay. So I will be talking about the Dabus series of litigations, which are one of the primary areas of AI interaction between AI and patents. But there are other examples of AI generated inventions. We have an AI designed plane cabin. We have race car chassis being designed by AI, and so on and so forth. Now, if we try to dissect these issues, it's also important to flag the broader and more normative question of whether AI generated inventions should receive patent protection in the first place. Because, well, patent systems provide certain incentives, mostly monetary incentive, exclusive rights, profits, potential profits anyway. Now, AI systems, are they really motivated by any of that? Probably not. There is no evidence that they are. On the other hand, it has been argued that but AI systems themselves are created by humans through resource-intensive efforts. And those humans may require incentives to develop these AI systems in the first place. If you give patent protection to an AI generated invention, then more and more people will be investing in producing the AI which can generate such inventions to begin with. If you don't provide patent protection, then those inventions, those AIs, the algorithm behind them, they may be protected as trade secrets, which is less robust. It affects transparency obligations in areas such as biology, life science, biotech, where only collaboration and disclosure can actually lead to further progress. That's why to withhold patent protection in such cases may be considered to be even detrimental, to this implicit rationale that we have, that we provide patent protection in return for disclosure to the public, which in turn generates further innovation. In fact, it has even been argued that the incentives for patent protection of AI generated inventions are so great that some applicants will actually end up lying, saying that AI has generated the invention. Now, of course, if that becomes trend, then that will affect the legitimacy of the patents obtained, and it will bring disrepute to the entire patent system itself. Right? So we have different kinds of policy discussions taking place all across the world today. WIPO, World Intellectual Property Office, they're doing it. The USPTO, the US Patent and Trademark Office, is doing it. The UK's Intellectual Property Office is doing it. Other jurisdictions, even in India, this discussion has started now. And in practical terms, the question for patent protection for AI-generated inventions, we can break it down into three distinct issues. The issues are distinct, but they're also closely related to each other. Question 1, can an AI system be named as an inventor? Question 2, can an AI-generated invention fulfill the requirements of patentability? And question 3, if we are talking about an AI-generated invention, then who is the owner of such invention? Now, this brings us to the DEBUS litigation. So, there was this project called Artificial Inventor Project. So, from 2018 onwards, the AI project, the Artificial Inventor Project, started trying to test the limits of patent law in the context of AI-generated invention. Then they started filing applications for inventions made by the AI DABUS across many IP offices all across the world. They're seeking patent protection. And this DABUS, this is an IP system, is an AI system which has been created by this person called Stephen Thaler. Now, it's almost 6 years since the DABUS litigations have started happening. The emerging consensus from all these cases, it has even been discussed in India, is that AI cannot be named as an inventor of an AI-generated invention within the existing framework of the patents regime. So you'll have to remember that when these cases were being filed before the court, or rather when they're being filed before the patent office and the patent office is maybe rejecting the application, then the person goes to court. Now, the court will have to apply the existing limits of the patents regime. The court can't come up with new rules for patents, right? That's not the job of the judiciary. So they're saying that so long as the existing regime remains, we can't name an AI as an inventor. Because in patent law, the question of inventorship is of great importance. The inventor has the he has the indubitable right to be mentioned in the patent. So if you look into existing laws in most jurisdictions, patent laws, they will always link the ownership of a patent to either the human inventor or an artificial legal entity like a company which has acquired the ownership right from the inventor. Like, for example, when an employer becomes entitled to the employee's invention so long as he's working under the employment contract. And that this requirement is not satisfied, no patent can be issued. So long as an invention must have a human inventor, AI-generated inventions can't be patentable. That's the consensus from the DEBUS litigation so far. Now, when the original DEBUS patent applications were being made, there were certain key assertions made. One is that the AI system DEBUS should be deemed an inventor, but that as DEBUS being a machine, it is unable to own property such as patents. Since that is the case, therefore the patent rights should accrue to DEBUS's owner. Now, there were multiple jurisdictions, EU, Japan, South Korea, UK, USA, where over and over again in the DEBUS litigations, it has been held that AI cannot be the inventor of an AI-generated patent. In other words, existing patent legislation does not provide for non-human inventors. And if you want to change this, well, change the law. Now, if we talk about the appeals or judicial review proceedings which have been pursued in certain jurisdictions, once the patent applications have been rejected by the IP officers, as so far the scorecard has not changed. The High Court or the whatever the appellate authority is there, they have not reversed the IP office decision. And in fact, so there was this appeal to the UK Supreme Court, which has affirmed the status quo that an inventor must be a natural person. DEBUS was not an inventor, never was an inventor under UK patent legislation. Interestingly enough, there is one jurisdiction which started agreeing to DEBUS that DEBUS can have IP rights if they want to. First one was South Africa. Later on, even Australia has been rethinking their position, original rejection position, but South Africa has successfully accepted the reverse application. Now, South Africa does not conduct a substantive examination before patent grants, like something like that Indian Patent Office does. As you may say that maybe one of the reasons why this might have slipped through. But the reasons for the decision of South Africa's patent office are not known. Some people have criticized this decision already because they say that, if you look into South Africa's patent act, that refers to the inventor with the singular pronoun him, doesn't even say it, right? So they say that even a non-gendered they would imply a human rather than some other entity in ordinary speech. So if you consider this decision, you've been hired by the defendant to defend this decision. So one can suggest that whether intentional or not, the decision was the right one, because that's how, if you take the purposive approach to interpretation of statutes, that's where you will land at. So South Africa's IP policy actually sees IP as an important instrument to promote innovation, nothing else. So if you just take away your mind from the substantive outcome first, we can also say that the global range of DBUS litigation that has also shown the spotlight on matters concerning the patent protection of AI-generated inventions. Right? And if you, at the international level, if you consider, WIPO has raised the question of whether IP law should continue to require only human inventorship or whether there are alternative solutions. Now, WIPO noted that each of the possible approaches to AI inventorship has potential implications across the complex IP legal framework. And he said, and WIPO stated that options will need to be considered in the context of local innovation ecosystems. Mind you, not national, not global, but local innovation ecosystems. In the UK, there was a government public consultation on the more overarching views, including patent protection for AI device inventions, etc. And conclusion of the consultation was that the public thought that there is no legal change needed because there is no evidence that UK patent law was inappropriately being used to protect inventions made using, say, generative AI or some other kind of AI. Now, most of the people who responded stated that no legal change was the best option at the moment. Let the technology develop first. Let me see it first. Then only we'll consider development. So, a lot of people have even taken the view that any changes to rules on inventorship should be harmonized at the international level. There were some people, of course, who supported some kind of legal change. But the majority supported the approach of expanding the definition of inventor to allow humans responsible for an AI system to be named inventor. Now, this was preferred over two other options. Okay, so they gave the options of allow an applicant to be named to name an AI system as the inventor and introduce a new patent-like right to protect investors or to protect inventions which are devised by AI. So, if you look into the US situation, the US has also sought wide-ranging stakeholder input on this current issue of AI technology in the invention creation process and on how to address inventions created with significant AI contributions. The question that was there that US had actually posed for the public was that should AI systems be made eligible to be listed as an inventor? And also, if you do allow this AI system to be listed as an inventor, will that promote and incentivize innovation in some way? That's a big question. Now, I think a couple of months back, in February, the USPTO has actually issued guidance on inventorship and they also sought comments. Now, among other things, this guidance stated that while AI systems cannot be listed as inventors, the use of AI system by a natural person does not, I repeat, does not preclude his or her qualifying as an inventor, especially if the natural person has significantly contributed to the claimed invention. Now, if you consider the academic circles, there are a little bit different kind of options that are being discussed. A, they say retain the status quo, say that AI systems can't be inventors. Or B, you list the AI system and its human owner as joint inventors. Or C, you recognize the AI system as the inventor with a human being as the owner of the invention. Now, none of these options, so to speak, they all have issues which are open to debate. Okay, like say if you talk about the recognition of AI inventorship, I'll say where is the criteria to assess whether an invention has indeed been AI generated. Because if you give all attributions to right to such a system, that would engender severe legal uncertainty. Okay. And you can also try to differentiate between the patent applications for human inventions and other kinds of AI generated inventions, like the introduction of sui generis category for the AI generated invention group. So on one variant of this concept, AI generated inventions could qualify for patent protection. It's fine. The company will be deploying the AI named as the inventor and owner under a work made for a higher type of model. Now, here too, there are certain problems to work out. It includes applicants attempting to game the system by characterize their applications to fit into the same category that provides for more desirable treatment. Right? And if you look into the second question, which is, can an AI generated invention fulfill the patentability requirements or not? Novelty, inventive step, industrial application. Subject matter has to be patentable, and sufficient disclosure has to take place, right? And remember that it is convenient to note the more general issue of patentable subject matter in the context of AI-related technologies. There are certain jurisdictions where scientific theories, aesthetic creations, mathematical methods, plant varieties, discovery of natural substance, and commercial methods, including methods for medical treatment, computer programs, they're generally not patentable. But now the rapid development of AI in turn has engendered discussion on whether AI-related technologies, like the AI system, they are patentable in nature. So I don't know, if you have come across this particular case filed at the English High Court, they had decided that an aspect of AI, an artificial neural network, did not engage the exclusion from patent protection of the UK Patents Act. Now the wordings of the protection as follows: that a program for a computer and etc., as such, that will be excluded from protection. So this allowed this individual to sell it. Now, the court also found that the claimed invention did make a technical contribution. It would therefore be patentable in any case. And after this case happened, the UK IPO office, so they suspended their guidelines on the examination of AI-related applications pending consideration of the judge. Right? And a lot of AI-generated invention will constitute softwares, right? So, or contain certain abstract ideas or mathematical theories. It may or may not qualify as patentable subject matter under the existing requirements, depending on, of course, the facts of the case. The lawyers love to counter it by that, the facts of the case. But if we look into the non-obviousness part that is necessary for a patent, there are two main issues of discussion which stand out in relation to the elements of the non-obvious requirement. Notional skilled person, the prior art the skilled person has reference to in discerning whether the invention is non-obvious in nature. Now, with regard to the first part, the notional skilled person. Now, an invention that is non-obvious is one that cannot be obviously deduced by a person with ordinary skill in the relevant field. So, because along with the patent, you are also getting time-limited monopoly. So, if you interpose this particular standard, it's an important filter. It prevents a patent from being granted to an invention which would have been created anyway without the incentive of exclusive rights. So this requirement ensures that patents are granted only for inventions that provides an appropriate level of improvement over the prior art, and so on and so forth. So US uses this term PHOSITA, PHOSITA, person having ordinary skill in the art. So there is a difference between invention and prior art, and it's supposed to be at least non-obvious to a PHOSITA before the filing date of the invention. But the UK considers a slightly different fictional person, being a person skilled in the art, need not be a Nobel Prize winner, but rather best seen as someone who is good at their job. Now, so that what kind of people will that be? Who's good at their job? A fully competent worker. And if you consider therefore the UK test, the question is whether the difference between the inventive concept and the prior art, it actually constitutes steps that would have been obvious to the person skilled in the art. Now, this requirement was clearly conceived in relation to human inventors. So, there was this judge in the US who had said the proper way to apply the obviousness test is to first picture the inventor as walking in his shop with the prior art references, and of course, he's presumed to know those differences, which hang on the walls around him. Now, to date, the non-obvious requirement has not been adapted for the examination of AI-generated inventions. Right? And questions have already been raised, like the Federal Code of Australia, the full code actually. It's asked in the Dabus litigation that if an AI is capable of being recognized as an inventor, then should the requirement of should the standards of inventive step be recalibrated in a manner that is no longer judged by reference to the knowledge and thought process of the hypothetical uninventive skilled worker in the field, and so on and so forth. So the crux of the issue, of course, is that what could be non-obvious to the human mind might well also appear trivial to AI. Point is brought home what this case called pyrimidine derivative. This involved proceedings to invalidate a patent that was granted in relation to a pharma company. Now, based on the facts, the compound was cited in the prior art, though in the form of a general formula. Okay. Yeah, by all means, if there is any query, feel free to use the chat box. Now, insofar as the idea is concerned, now more and more inventors and companies are going to use powerful AI, right? So devise new inventions and stuff like that. Now, otherwise, the legal standard has to be adjusted. Otherwise, the non-obvious requirement will be far too lenient. With human beings who are owning the AI system, they will keep on claiming the credit, even though the majority of inventing is performed by the AI system. At some point, therefore, the patent examiners will have to start assuming that the skilled person also has access to AI. And that will raise the bar for obviousness in the patent process. This will make it harder for human inventors to push their inventions across the line, as the adoption of the notion of an AI-assisted skilled person, or even the replacement of the individual by an AI skilled system altogether, would naturally deem human-created inventions obvious. Instead, it has been argued that a skilled person using AI can potentially create every invention. Therefore, everything is obvious. Now, that will be a bit of a funny scenario. And of course, it's also difficult to establish what sort of AI system should constitute the skilled AI, because the very black box nature of AI systems and their dependency on their output on these data sets that the system in question has been trained on, these are all factors. Like, that's the reason why in India, we actually have started, among other things, using explainable AI or XAI. Most of the algorithms which I've been a part of developing or working together for the purpose of creation have all been focusing on explainability more than anything else. Now, with regard to the prior art aspect, at present, a skilled person is not expected to be familiar with the prior art in other fields unless there is a nexus to the issue at hand. But a skilled AI system would have the computing ability to access far more prior art than a human skilled person. So they can expand the scope of prior art to almost an infinite collection. And that raises the non-obviousness bar even further. So I'm not going to spend more time because we have other types of legislation, other type of IP also to talk about. But we have to consider that why is there these so-called other IPs? What are the challenges? What are the other issues that they represent? Some of which will be similar to patent issues that we were talking about right now. Some of which will be similar to the copyright issues that we have learned earlier. But this, think about it. Let's start with designs, registered designs. Right? There is no the discussion analysis of the issues which are under patent and copyright laws. You'll find out that they're applying equally to a lot of AI generated designs also. Now, so far, there has not been a lot of case law development in the AI in designs regard, especially AI-generated product designs, which are already happening right now. The question is, can an AI system be a designer? Think about authorship of AI-generated designs. UK, interestingly, is a jurisdiction which has legislative provisions for computer-generated designs. I mean, that's very similar to its legislative provisions for copyright authorship of computer-generated works. Plus, we have the UK Registered Designs Act 1949, the UK CDPA 1988. These are for registered designs and unregistered designs, respectively. Now, both of these acts provide that the designer of a design means the person who creates it. In case of a design generated by computer in circumstances such that there is no human author, then the person by whom the arrangements and necessary for the creation of the design are made shall be taken to be the design. So it's like a deeming provision, so to speak. So who is the owner of this design then? Well, obviously the system won't own the design. It does not have legal personality yet. But in identifying a party to vest ownership in, there are issues of certainty as well as issues of connection with the actual design to achieve the policy aim of encouraging AI-based innovation, and in turn also AI-enhanced innovation, so to speak. I mean, UK, the designer is the owner of the design. So attribution of ownership in case of designs without a human designer would have to be the person by whom the arrangements necessary for the creation of the design are met, right? So if you use that concept to determine ownership, that will in turn throw up the problem of how do I identify the appropriate person? Cases of complex AI with multiple actors involved. Same issues, same suggestion for resolving the issues of authorship and ownership for copyright. The UK IPO had responded to this call for its views on AI and IP back in 2021, and it stated that, and it acknowledged that the use of AI in generating designs is a developing area of technology. This issue will be kept under review in line with any review of similar copyright provisions. Trademarks, they don't have the equivalent concept of an author and inventor, right? So in many jurisdictions, trademarks are typically registered in the name of a legal entity or an individual. Now, the position in most jurisdictions is to treat the person in whose name it's registered as the owner or proprietor. Right? In the UK, when you try to file a trademark, you have to file an application which refers to this which will refer to you as the proposed owner. And if you look into UK IPO's manual of trademark practice, more specifically, I believe section 1.1. So that explains the essential requirements for filing, and that explains while doing so that the applicant becomes the proprietor once the mark is registered. That's the UK position. In the US position, rights to a trademark can be acquired by just being the first to use the mark in commerce or being the first to register, both. Now, this appears to remove any live questions as to whether AI-generated content that could function as a trademark can be legally protected, because if it is duly registered, it does not matter how it was created. So it would thus appear that anything produced by AI that could function as a trademark, in some jurisdictions at least, could be available for adoption and registration as a trademark. Now, the question of who is the owner of an unregistered AI-generated trademark, that will likely generate the same issues. Who is the owner of AI-generated output under copyright law? Right? We will not go far back there. But there is also another interesting question. If you keep on using AI, can that affect traditional trademark law concepts? Because the increased usage of AI in consumer recommendations, purchases, etc. So that can affect the way consumers perceive and interact with brands. And in turn, this may challenge the application of traditional tenets of trademark laws. Keep on increasing the use of AI assistants, Alexa, Siri, search engines, customer service bots in online market spaces. Keep on doing that, and that will correspondingly result in less direct participation by consumers in purchasing decision. The AI will make the decision for me what to choose. Data-driven recommender algorithms, they're already there. They make personalized product suggestions, which has less to do with brand recognition and quality, more to do with subscription, historical purchasing decisions, etc. Maybe that you are, as a consumer, you are not even aware of these pre-selected factors. Go to Amazon, it will have a general product suggestion feature and recommendations based on your order. You can even set instructions for online purchase recommendations based on price point, based on availability for shipping, etc. Now, therefore, online retailers these days are even providing for product substitution, where the selection of a substitute may be determined by other factors other than brands or product quality, etc. Interestingly enough, in 2023, there are at least 310 million Alexa users worldwide. So you can figure out how many sales are being made, chosen by those AI, right? So if you look into, because of AI, by using these kind of scenarios, what are the potential changes in purchasing behavior that ones we just mentioned? How does it raise legal concerns about registrability of trademark or trademark infringement? See, I'll just tell you some of the questions which are being asked right now in this field. Question one: who is the average consumer for determining likelihood of confusion between two conflicting marks? What can be the parameters of an AI consumer if you consider AI as a consumer? There is this terminology in the trademark law for those who have studied it. It's called marketplace confusion. Does that apply to AI? Do concepts like imperfect recollection routine, they continue to apply when AI is supposed to have perfect recollection? So there is no question of mixing one brand with each other. AI will remember what exactly the brand that he's come up with earlier. We have these voice assistant technologies and like Alexa, etc. So in the light of their development, that kind of technological development, what is the importance of oral or conceptual comparison of marks in future in determining likelihood of consumer confusion? Should phonetic similarities be granted additional weight? If the AI suggests a product that infringes a registered trademark or is a counterfeit, would the purchaser be liable? So all of these questions are actually raising at this point of time, right? So, there is this continued commentary. I'll just give you an example. Now, Alexa by Amazon, that uses an NLP system, natural language processing system, that's powered by data and machine learnings. It talks to users of Amazon's Echo products. Now, that itself is based on a patent which was filed in 2021 for Amazon engineers. They filed for an AI system which is designed to engage with human speech. Now, Alexa-enabled devices, they can play music from Amazon Music, control smart home devices, order products, etc., etc. And one of its functions is to aid Amazon Prime members shop on the Amazon website. If I, as a user, know exactly what I want, then I can mention the brand and quantity. But if I don't know or don't have any particular brand in mind, I can give a description and Alexa will pick an Amazon Prime item for me. So, there's continued commentary that consumers' allegiance this way will shift from trusted brands to trusted AI assistant. But there are security and privacy concerns. Only in 2023, this is one scenario back in June, about a year back, Amazon was fined a combined total of almost, I think, 31 million US dollars by the FTC, the Federal Trade Commission, for preventing parents from exercising their deletion rights, that is the right to be forgotten, under the US Children's Online Privacy Protection Act and so on and so forth. So it's storing sensitive voice geolocation data for years and using its own purpose. Then the question, of course, we are almost out of time. So I'll just tell you a little bit about some other aspects of right of publicity, passing on. Now, AI systems are increasingly able to produce material that convincingly replicates the voice and appearance of a person, deepfakes and everything, digital replicas. There's this people like Bruce Willis, they're actually allowing in AI, they're actually allowing selling off their right to digital images. They even after their death, their digital replicas can be used for movies and shows and stuff like that. So there are a few questions. I think somebody has asked here how to determine the legal personhood of AI generated inventions. Well, that depends on the jurisdiction. If a jurisdiction decides tomorrow to give AI the same kind of artificial legal personhood that we have given to companies, well, then that solves part of the problem. But it has to be legal recognition, right? So your legislature will have to take that policy call. The next question by Susnada regarding a usage of AI in legal avenues. Right, avatar of minor girl, gang raped in video game scored. Yeah, so I mean, how do you navigate in this scenario? I would say that try to consider that any law that you are planning to use in the field of AI, because of usage of AI, how is it going to change? Or because of usage of AI, how can it be better implemented? Because AI is not only about infringement. We can use it for the purpose of detection, enforcement, better enforcement also. Antitrust competition authorities across the world are using AI in order to track market developments, which will help them prosecute. So that is happening. And ringing bells at home, which rings when someone switches on the key, is this an AI? No. I mean, without seeing the technology, I can't really specify, but most of what is being used are very rudimentary usage of very specific AI, if at all. Automation, mere automation is not AI. Okay, so the system is that the system has to learn by usage. If it becomes better, so based on what if say, for example, I have a bell machine which has figured out the pattern in which I ring the bell. Based on that, it will announce this person has come. Then you can say yes, there is some AI model underneath it. And somebody is asked how much of a threat AI can pose in fair use of data for designing inventions. I mean, huge. That's one of the issues with this generative AI problem, right? And how much fair use is happening, and whether third-party data is being infringed, etc. Interesting, in India, when the Davos litigation was happening, the Control General of Patents laid down objections for same reasons. Sections 2 and 6 of Patents Act, formal and technical examination. They say Davos is not recognized as a person. Earlier, we have cases like in India, like GV Mohammad Ibrahim versus Alfred Shapranek. Court had ruled that neither a corporation nor a financing partner can be the sole inventor. And it was also held that only a natural person who will actually contribute the skill and knowledge to the innovation will be able to legally claim the inventorship. So these things are already happening, right? It's just to think about it. Tom Hanks, and many of you would have watched his movies. So he had written on Instagram some time back that there is a video out there promoting some dental plan with an AI version of me. I have nothing to do with it. So there are examples AI generated. There is this music track, Heart on My Sleeve, that was uploaded by the TikTok user on platforms like Spotify and YouTube. It got millions of hits. Now, Universal Music Group, they issued a takedown notice. Spotify and YouTube took down the video. Then there is a Chinese video platform, Bilibili. So that was flooded with covers of AI generated songs. So and so on and so forth. So, in India, Anil Kapoor has recently done this. The Delhi High Court ruled in his favor against defendants that included Simply Life India for using his image and likeness with AI tools, and his trademark thing called like Jackass, something like that, to generate materials for commercial use without his consent. Interestingly, what Anil Kapoor obtained is something which we refer to as an omnibus injunction against all kinds of independents, named and unnamed, from using his name, likeness, images, using any kind of tech tools, like including AI, face morphing, GIFs, etc., etc. So the claims which Anil Kapoor brought included those in personality rights, including those in passing off. Right? So we know common law tort of passing off, etc., exists in this regard. So I'm almost out of time. So I'll just try to conclude by saying that 1 hour of course is not enough to do this. So can AI models and tools infringe IP? Yes. When the output of an AI model or tool is substantially similar to an existing work product, when a patent is possibly infringed by the AI model in the process of developing an invention, when the training data which is used in the AI is actually taking unauthorized third-party work. So all of these things can lead to problem. I mean, potential infringement issues. There are, of course, subject to the usual rules, de minimis copying and stuff like that. If you look into Getty is an image company. They had filed lawsuits against Stability AI. Getty cited that there's an AI-generated image that showed a distorted version of its watermark as proof of copying by the AI model. So that case is still going on right now. Anderson versus Stability AI and so on and so forth. Midjourney and DeviantArt, they are all being sued for direct infringement by generative AI models. So the idea is, of course, at the end of the day that, if you try to take into consideration what is happening where, even as policymakers are continuing to grapple with these issues concerning AI and IP development has continued at a rapid pace. In the view of this rate of development, the stakeholders, businessmen, etc., they've already embarked on offering various solutions to right holders, customers, etc. Be it in the realm of AI copyright, AI patents, technological solutions which are being offered to creators to stop their content from being used to train AI without their consent. HTML tags, there are some other things called data poisoning, and so on and so forth. Now, whether these measures themselves are permitted by law, how they will play out in practice, these are exciting stuff for the lawyers to work on, think about. If you are looking at the material that existed currently, you have to recognize that the starting points are often different in different fields of IP. That's to be expected. Responses are also very much domestically located depending on your jurisdiction. But what remains these kind of efforts, cross-border collaborations, innovation across jurisdictions, interdisciplinary issues, these efforts can start with the promotion of knowledge sharing and best practices among stakeholders, learn from each other, ahead of the development of more efficient and effective legal frameworks. Law cannot develop in isolation. So today we stand on the cusp of a transformative technology that's going to shape our lives in the time to come. At this juncture, lots of questions, no easy answers. So policymakers should engage with the full range of domestic and international stakeholders in open and constant dialogue. This will enhance the prospects of uncovering where balance may best be struck. For one, for right holders to receive equitable treatment for their inventions, even as we promote the continued innovation of AI tools, which can well enhance our lives in the future. So yeah, that's all to say about this. There's a huge future of AI in legal field. I mean, apart from usage of AI in other fields which will have to be legally governed, we also have legal AI specifically. I mean, many of my work is extensively focusing on legal AI, legal prompt engineering, data extraction from documents, and legal research, legal bots for judgment prediction, and so on and so forth. Yeah. So yeah, that's all I have to say. What do you? Thank you, everyone.
If there are any other doubts, you can use the chat box or raise your hands. I think we still have 2-3 minutes.
Either that means that everybody has already got whatever I had to say, or the other way around, where nobody has got whatever I had to say. Either way, either scenario will. I will like to assume the former one. Okay.
Yeah, I'm sure, sir, that everyone got what your session was. Anyways, I think there are no other doubts. And thank you so much, sir, for taking out the time for being here. The session was filled with plethora of knowledge, and we hope on many more such collaborations with the Legal Voice and you. So thank you so much, sir.
Thank you, everyone.